You didn't do it?
There we go.
Welcome, everyone. I'm Susan Crowell. I'm the Executive Director of My Autism Ally, and we are excited to have Gordon Holmes with us tonight from Mass Mutual. Gordon's going to talk about guardianship and ABLE accounts tonight, and I'm really excited to have Gordon with us. I know Gordon personally. I've heard him speak lots of different times. Gordon is a parent of a son on the spectrum, and so it always impresses me so much because he shares about his life, and he's just so passionate about what he does. And so I think you are all in for a real treat, and I'm just excited to have you here, Gordon. Thanks for coming tonight.
Well, thanks very much. Appreciate the introduction. We will start this evening with guardianship, and please, everyone, feel free to ask questions. Looks like we have a chat function, so thanks so much for Autism Ally making your Zoom platform available so we could do the chat. So if you do have a question, feel free to click on the icon that looks like you're texting or something and enter your question in the chat area. Okay, I'm going to get some water. There we go. Okay, all right. Yes, I'm a special needs planner. So my practice focuses almost exclusively on working with families that have a member with special needs. Sometimes it's children, young children to adult children, and sometimes it's siblings that we help plan for. So the practice focuses on the legal, financial, and government benefit issues that accompany the special needs journey. And so this evening, guardianship will fall on the legal side, and ABLE accounts will fall on the financial side. And we'll have a little bit on government benefits thrown in because, well, you just can't avoid the government benefit issues if you're talking special needs. So I think it'll make for a robust both presentation and hopefully discussion or questions. So again, do feel free to enter questions into chat as we get going. We, I think, have a hard stop for 8 o'clock. So I think the PowerPoints will run until maybe about a quarter or so till 8. And so we'll make sure to have questions at the end, but don't feel like you have to wait. If you want to throw a question in chat, we'll handle it as it comes up while we have the very PowerPoint material or references right in front of us. So while we toil hard to help families that have a family member with special needs, we're not all things to all people. So of course we have our disclosure. And this evening for guardianship, we're going to talk about what guardianship is. And, you know, it's kind of interesting because some people think, oh, my kid's 25 or my child is 30 or something. And so guardianship is, well, that's history that no longer applies to us. But interestingly enough, there are issues regarding guardianship that apply both in the earliest days of the journey through the latter point. So for anyone that thinks that guardianship doesn't apply, hang in there. I think you'll find some of what we talk about does resonate for you. At a minimum, planning for the future and who may follow you as a guardian for your child or dependent with special needs. Terms to know, state laws, types of guardianship, appointing a guardian, liability of a guardian, kind of answering those questions of, if I'm a guardian, does that mean I'm liable for or an accomplice to anything that they do? That type of thing. So we'll talk about that. Removal and termination of a guardian, how that happens, and alternatives to guardianship. So here we go. So guardianship is a legal relationship between a capable adult, the guardian, and a ward, the protected person or the person for whom guardianship is petitioned or obtained. In most states, the law presumes that individuals over the age of 18 can make their own decisions, that they don't need help. Some may feel it is necessary to apply for guardianship to protect their loved one that has special needs, because without guardianship, parents have no legal standing, and that's a concern to many parents, and so as a result, many parents of children with special needs do decide to go to court and obtain guardianship, and we'll talk about the process this evening. Guardianship does vary by state. So guardianship is largely an issue by state law. Guardianship advice should be state specific, and seeking local counsel to get specific state information is always a good idea. An example of how guardianship differs by state is recently as just 4 years ago, to obtain guardianship for a son or a daughter with special needs in the state of Kentucky, you were required to go through a jury trial. So literally they impaneled a jury of your peers, and the jury would hear the evidence with regards to the case for guardianship, et cetera, could ask questions and so forth. And many families found it quite unnerving. Fortunately, finally in 2018, the jury trial was started being waived as long as the guardianship was not contested. But that's just an example of how it varies by state. Also, if you do obtain guardianship in one state and then move, then the guardianship really should be transferred to your new jurisdiction or new county, that type of thing. So even when a person moves, guardianship needs to be revisited. So the types of guardianship, there is full guardianship as noted on the left, and full guardianship is when you have comprehensive decision-making authority and responsibility over the person, that is their physical person, their well-being, where they're at and what they're doing, as well as their financial affairs. So that's what we call complete or full guardianship. As an alternative, there is limited guardianship. Limited guardianship in the state of Indiana is very common. More often than not, the limited guardianship is guardianship over the person. That is the person, their health care, their physical well-being, where they're located, what they're doing, etc. And the reason that limited guardianship is often sought or obtained is because the individual with special needs may not have any financial resources, meaning there may not be an estate to obtain guardianship over. And so in some counties, judges are reticent to provide full guardianship when there may not be financial assets to be guardianship over. So for that reason, some people end up going to court and obtaining limited guardianship. There are some situations where a person obtains limited guardianship and then at a future point, the individual with special needs ends up having some money, whether it's receiving it by gift or inheritance or sport books, bettings win, or winning lottery ticket, or who knows what. And then the parent has to go back to court a second time to expand the guardianship from limited to full. And so learning that that's sometimes the case, many parents will simply pursue full guardianship if possible, if the judge will grant it right up front, though there may be limited or next to no financial assets. And the objective being to not have to go back to court later to expand on the guardianship. Joint guardianship is usually a situation where there's a single individual that's guardian over another, or joint guardian where you have more than one individual sharing the guardianship authority. In my practice, I see two people serving as co-guardians or an individual serving alone as guardian. I have not seen a case, at least to date, where there's guardianship by committee, meaning we have 3 or 4 individuals that are serving as guardian. I think that the court prefers either one or a couple of people. Otherwise, everyone points fingers at each other in terms of who really is in charge. And then it creates a complicated, difficult situation when the guardians are not agreeing. And then you've got, anything from competition to dissension to whatever. So usually it's a parent, a combination of parents, a parent and a sibling, a combination of siblings, this type of thing. It can be a professional guardian. There are people that hold themselves out as professional guardians. It does not have to be a family member. Most often it is, but again, does not have to be. So these are the different types of guardianship as they apply in the state of Indiana. As far as the process is concerned, of course, it's the government's involved, so you have paperwork, of course. The county attorney's office reviews the petition. The petition is respective state paperwork, the paperwork that the state of Indiana provides to petition your county court for a hearing. And so there's petition paperwork, and then typically attached to the petition paperwork is a letter, most often from the pediatrician or the person's primary care physician, confirming diagnosis and perhaps weighing in on the appropriateness of guardianship. The letter from the doctor is just very important because the doctor is seen as someone who is not biased, meaning the doctor has no financial gain, nothing to benefit from. And so that impartiality carries a lot of weight in a guardianship proceeding. And so for that reason, one needs to have a letter from the doctor, and then that gets attached to the petition that goes to the county courthouse so that the county clerk can schedule the hearing with regards to the guardianship matter. The court will appoint an attorney for the respondent to represent them. That is the person responding to the request for guardianship, or the ward or protected person. So the court can appoint someone to represent them. They don't always do that. Typically, the more of a metropolitan area that you're in, the more likely the court is to appoint a representative for them, or what may or is sometimes called a guardian ad litem. Okay, excuse the yawn. I put my wife on a plane to California this morning at 4 o'clock. And so it's been a bit of a long day. She's headed out to the West Coast to be with my Air Force daughter. I have a daughter who's an Air Force captain, and she's having her tonsils out tomorrow. And I am told that having that done as an adult is a rather unpleasant experience. And so my wife is going to be with her because the Air Force told her that she had 2 weeks to deal with her tonsils. So she did ask, what if she needed more time? And oh, they were quick to respond, no problem at all. Just be back in 2 weeks. So then her mom, my wife, decided, well, I think it's time for the cavalry then. So she headed out to California to be with her through that ordeal. Okay, we do have a comment in the chat box, so I'm opening this up, and it says, if you have power of attorney or everything, do I still need guardianship? So great question, and the answer is you would not have both, you would have one or the other. So having guardianship basically means that the person lacks capacity. So, and we'll get into the alternatives in a moment, but basically a decision is made of whether to pursue guardianship or the alternative. And one of the alternatives is to have the young person execute or sign a durable power of attorney and or a healthcare directive authorizing you to be their agent or act on their behalf. But they have to have capacity. What does that mean? They have to have the capacity to understand what the document is, what a durable power of attorney is, what a healthcare directive is, because the attorney assisting you will be looking for them to sign those documents, affixing their signature to them, signifying an understanding of the document and their approval of it. And so if a young person has the capacity to understand what a durable power of attorney is, what a healthcare directive is, and the ability to affix their signature to said documents, then that's an indication that they have capacity, and perhaps those alternatives to guardianship should be considered. If they lack capacity, if they don't have the capacity to understand what a durable power of attorney is, what a healthcare directive is, et cetera. Then on the flip side, that may be an indication that guardianship should be considered, because if they can't execute a durable power healthcare directive because they don't understand them or lack capacity, and there is no guardianship, then no one's in charge except for they themselves. And if they don't have capacity, they may not be the best person to advocate for themselves or to be in charge of their affairs. You know, and you might bebop along and things are just kind of cool and quiet and boring and this type of thing, and then something happens. And so sometimes the guardianship isn't the day in and day out, but it's the events that occur from time to time where you're so thankful that you're able to insert yourself into a situation and advocate for your loved one that has special needs, whether it's a government agency that's not handling things correctly, whether it's being the representative payee for a Social Security benefit, whether it is having a serious conversation with a doctor about a medical procedure, surgery, medication, change in medication, how they're doing in response to treatment, you know, et cetera. There's so much on the medical side with our children with special needs. But in the absence of guardianship, you need to have a durable power of attorney or healthcare directive. And again, if they don't have capacity for that, we're back to guardianship. So hopefully that kind of helps answer the question. Depending upon the county, if you're in Marion County, of course, they pull out all the stops. But typically the fourth bullet point there, a hearing is normally scheduled within 60 days. Depending upon the county, you might get a hearing scheduled within 30 days. It just varies. The court will appoint a team, if appropriate, to evaluate the guardianship petition, et cetera. Reality is more than half the time, it's either virtual or in person, but you're in and out of there in under an hour. These things do not take all day, especially if the petition is valid and you're well prepared for the proceedings. The county attorney prosecutes or the questions the situation, making sure that all the I's are dotted and T's are crossed. At least one member of the team may testify or speak to the judge, that type of thing. Again, it varies a little county by county, but working with an attorney is so valuable because they're in court every week and they know what flies and what doesn't, and they can assist in making sure that all of the I's are dotted and T's are crossed. Appointing a guardian requires proof to the court that the person is not able to care for him or herself. So part of the petition and the letter from the doctor is showing the lack of capacity. The physician certification, as we just discussed, in some states, more than one state agency may be involved. In Indiana, it may depend upon the county. All interested parties must be notified. That means if we have parents that are not married, maybe they were never married or married and since divorced, this type of thing, then state statute does provide for them to be notified of the guardianship proceedings so that guardianship could not be awarded without their being aware of the hearing so that they can, again, insert themselves, sometimes for better, sometimes for worse. It varies, but an effort has to be made to notify them of the guardianship proceedings so that they can speak to the situation if they care to. All interested parties must again notify the court, appoint someone to be to represent the individual because the attorney is representing the parent, not the child. The person represented to or selected to represent the ward or the person for whom guardianship is being sought, again called the guardian ad litem. Okay, a guardian must use reasonable care and caution when making decisions, the prudent person rule. Unless a guardian acts negligently, though, unreasonably or irresponsibly, or the let's see here, a guardian is generally not personally liable for the actions taken on behalf of the protected person. So a guardian is not liable for the trouble a ward gets into. At the same time, if you are the guardian, then you need to make sure you're compliant in submitting whatever reports the county requires. Some courts do require the biannual or every other year reporting that they can. Others do not. But if your county wants you to submit the report, you'll need to, because the law gives them the right to require that to continue the guardianship. Depending upon where you are in the state, there's usually some expense in having the attorney assist you. If you're going to pursue guardianship, spending for an attorney is money well spent. And it just depends upon where you're at, as to quote unquote what the going rate is for an attorney to assist you with the guardianship proceeding. In the lesser populated areas, kind of out in the hitherlands, as I call it, you may be able to get guardianship done for $1,000-ish. Here in the metropolitan areas, such as Northwest Indiana, Fort Wayne, Indianapolis, Evansville, etc., you'll probably find guardianship closer to $1,500. But most of the time when guardianship is being pursued, not always, but most of the time, the child is turning 18, and that's what's prompting the request for guardianship. And if you're going to court to obtain guardianship for this individual, then chances are you're applying for SSI for them. So most of the attorneys that I work with will accept a payment plan so that you would have perhaps 6 months or even a longer period of time to pay off the fee for getting assistance with guardianship. And with SSI coming in per month, and the SSI benefit is already up to $841 a month. Again, that's $841 per month. That's tax-free, both federal and state. And by the way, if your child is getting $560.75 or rounded off to $561, then we need to talk, because Social Security is considering them as receiving in-kind support or maintenance. And we need to work with you to get their benefit raised to the full benefit amount, which again is currently for 2022, $841 per month. With cost of living numbers that they're talking about, my calculations indicate that next year the benefit's going to be darn close to $900 per month. Can you imagine? $900 a month, tax-free, both federal and state. It is remarkable. It's just, yeah, wow. Never thought I would see numbers that big. It goes far, it helps pay bills. It really makes a meaningful contribution to the household expenses. Okay.
Hey, Gordon, this is Susan. I'm just going to pop in with a comment here, if I can.
Sure.
Here in Northeast Indiana, so especially if we have people watching this later, we do have some options for families who are seeking guardianship for their loved one that are lower cost than what you mentioned. But those options do require you to be doing things. You're going to want to give us a call at My Autism Ally. You can email us as well. Info at My Autism Ally. Our phone number is 260-207-4686. But you're going to want to get on it a little bit earlier. You're not going to want to wait as close to 18. The reason those options are cheaper is because they do them in mass. And so once an individual turns 17, I talk to families about guardianship just to kind of put it on their radar and let them know that there are some more affordable options, but they've got to act on that sooner rather than later.
Okay, wonderful. Thank you. Thank you so much. There are some options throughout the state. There is Indiana Legal Services, as an example, which is partially funded as a nonprofit through grants and this type of thing. There is a representative in the Fort Wayne area that can help. That's one option for those that are financially challenged. In Indianapolis, there's the Northside Legal Clinic. There's also a statewide organization called Disability Legal Services, and it's a nonprofit. I'm familiar with them because I financially support them. And so Susan is absolutely correct. For those that need guardianship, where guardianship is appropriate, but the cost would be a deterrent to obtaining it, then we need to figure out a way. We need to be supportive and helpful to you. And so, you know, let us know so that we can get you connected with resources that will match your ability to pay. The protected person reaches age 18. These are examples when guardianship terminates. So if guardianship was obtained for a minor, they're turning 18, can cause the guardianship to lapse, and one would need to have to go back to court. If the protected person is allowed to marry or marries before age 18, protected person is no longer incapacitated, perhaps through medical treatment or therapy or something. They reach a point where they're able to handle their affairs. The protected person dies, of course, that would terminate the guardianship. If guardianship of the estate is obtained and then the guardian or the estate is exhausted. These are additional examples where guardianship can be terminated. You know, there's another thing that I should mention, and that is that just because you obtain guardianship does not prevent the person from being able to drive or to vote. So it is possible to secure guardianship and for your protected person or the one that you have obtained guardianship for to still be able to exercise their right to vote or drive. So, okay, and if you do move out of state, this type of thing, or the protected person were to move from here to Oklahoma, believe it or not, there is a process of Indiana releasing the guardianship and the state of Oklahoma, respective county, taking over the guardianship. So guardianships can be transferred from one locale to another. Typically, it's a lot smoother when you have an attorney assisting you. And sometimes you need an attorney where the guardianship used to be to go to court to get it released. And then you may need an attorney assisting you in the new location to receive the guardianship. So there is like a passing of the baton, so to speak, from one government locale to another. As far as alternatives, and we touched on this earlier, but there are alternatives to guardianship. So in the state of Indiana, there are representative payee, and that's the person that is selected to handle the Social Security funds that are being paid. That may be SSI for supplemental security income. It may be Social Security disability benefits, or it may be survivor benefits if a parent has passed away, this type of thing. So representative payee oversees what's going on with the Social Security benefits. That's a really important role because even if you're a legal guardian, if you're not the representative payee, Social Security is not going to work with you. So usually, there usually is a single representative payee. Again, it's typically not by committee. So in two parent situations, one of the parent needs to don the hat of the Social Security parent because there's kind of a learned expertise over time as a result of working with Social Security. But representative payee is the one that can talk with Social Security, change banks as to where the funds are going, question the benefit amount, make inquiries, etc. We do have a couple of questions. How does guardianship work when an individual is traveling across state lines? And the answer is traveling across state lines does not invalidate the guardianship. So if you're a guardian here in Indiana and you go on vacation to, oh goodness, Houston, Texas, then you're still the guardian. However, if you do change the permanent residence, so you and your ward move to Houston, then once you've established permanent residence there, that's where your driver's license shows you living, that's the address you're filing your income tax return on, etc., then you would want to explore the process of having the guardianship transferred to your new location in Houston, Texas. Okay, so continuing on with the question, or if they winter in Florida and come back to Indiana in the summer. So wintering in Florida usually is not a reason to transfer the guardianship. So wherever you see the permanent residence, the long-term residence being, that's usually where the guardianship sits. Okay, so there are alternatives to guardianship. Those include representative payee, healthcare representative, the durable power of attorney, or specific power of attorney. There is someone that's the trustee, and that's not the guardian, but they in essence are the overseer of funds that may be on deposit in the trust. There are protective proceedings in some cases where the proceedings are not open to the public, and then parental powers. So when it comes to parental powers must be appointed guardians where there's significant amounts of money or property or other assets involved. So that's going to court to become, again, in charge or guardian of their estate. We talked about the representative payee. That's so important. I recently had a person I was working with, her husband had passed away due to MS and COVID, very unfortunate. He had been the representative payee, and he was at the time of his death. So he went downhill rather quickly, which we've probably all seen friends or family members in the last 2 or 2+ years do. And he passed away. And when he passed away, he was the representative payee. In other words, the responsibility for that had not been transferred to the mother of the son with special needs. So there it was, he had passed away and Social Security would not talk to her. Well, that's awkward. So we're working through that situation, but it's best if someone is fading, has meaningful health issues, to go ahead and transfer the representative payee before the person's situation becomes so dire that they cannot serve. So something to think about. Periodic accounting may be required. Used to be Social Security wanted accounting every year. Now they audit on a random basis. Okay, healthcare representative, making healthcare decisions for someone, designating them in a document, durable power of attorney, handling the business affairs. These are very important roles, and getting a durable power of attorney or healthcare directive is relatively inexpensive. But either that or guardianship, something should be done. Okay. As far as trust is concerned, this is being a trustee of a trust. So if one is going to fund a trust, either if parents are funding a trust or they're leaving monies to a trust via life insurance or retirement fund, beneficiary, etc., then a trustee is selected, and that trustee is the person that oversees or operates the trust. So, and it just talks about some of the duties that they have there. Protective proceedings has to do with any protective order or specific orders in regards to an incapacitated person. And then parental power. Prior to the age of 18, guardianship is rarely required. But part of it would be if they were to inherit, you needed to go to court to obtain guardianship over their estate. All right. If there are any remaining questions on guardianship, now would be a great time to have them. Next, we will go to ABLE accounts, which a lot of information there, and a recent development actually that I'll be excited to share with you. Let's see here. There we go. There's the ABLE Act. Okay. All right. If somebody can nod or something, just to let me know that the ABLE account slide is up on the screen. Okay. Yep. Okay. Sounds good. All right. If anybody's having trouble seeing the slide, please let me know. Put something in chat or, okay, I see a thumbs up. Thank you so much there, Susan. Okay. Okay. So ABLE accounts. ABLE accounts have not been around that long. They're a newer item. You know, after you've had something for a few years, it's easy to just kind of think, oh, we've had those forever, but we really haven't. Indiana adopted their ABLE accounts, I think in 2016. So we've had them here for 5 or 6 years. They are definitely growing in popularity. And we have also enhanced ABLE accounts from the legislation that was originally passed in 2014, bringing them about. So the ABLE Act, otherwise known as the Stephen Beck Jr. Act, and ABLE stands, by the way, for Achieving a Better Life Experience. The legislation passed at the end of 2014. The reason for Stephen Beck's name on it, that was the dad of a daughter with Down syndrome out in the Virginia area. And he was saving with a college account for sibling or siblings of his daughter with Down syndrome, and got rather frustrated with the fact that there was no saving option for her. So he slowly advocated for this legislation. It worked through Congress. My understanding is it took 7 years to get a hearing and pass. And since then, it's been catching on and growing quite a bit. So very exciting. The legislation was patterned after the 529 college savings accounts. And the legislation, now most states have ABLE accounts, bottom line. I think North Dakota does not. They use Minnesota's plan mostly, but most states have their own. In 2017, the Tax Cut and Jobs Act came about, and it brought enhancements to ABLE accounts. So ABLE account was passed originally in 2014, and somewhere close to 3 years ago, legislation was passed updating the ABLE accounts and enhancing them. So I guess who's eligible? Eligibility requirements? Sure. One needs to be blind or disabled prior to the age of 26. So there's a movement underfoot to raise the eligibility age so that even if your disability began, let's say at age 30 or 35, there's a push to make ABLE accounts available for family. But at the at the moment, the disability needs to be early onset before the age of 26. Now, if a person has a diagnosis before 26 that's going to steadily cause less function or to have more significant special needs, then that can work. And some of the conditions that come to mind are spina bifida, hemophilia, and muscular dystrophy, just to name a few. Okay. Can be over age 26 when opening the account. This is a question that comes up sometimes. It's just that the disability itself needs to have occurred prior to turning 26. If the age criteria is met and an individual is already receiving SSI or SSDI, they're automatically eligible. So if age criteria is met and an individual is not receiving SSI or SSDI, then they must meet Social Security's definition or have a significant functional limitation. So most of the time, not always, but most of the time in recent years with ABLE just kind of becoming better known, more often than not, ABLE accounts are being set up by young consumers that have a part-time job or for some reason have money flowing in that's exceeding their ability to consume. So, it's certainly nice to know that there's avenues to build up savings toward significant life events or purchases. Okay. The maximum annual contribution for an ABLE account is $16,000. So that means between January 1 and December 31st, one can deposit into their ABLE account as much as $16,000. Now, the funds deposited in the account do not have to come from the consumer, meaning grandparents, great-grandparents, aunts, uncles, parents, successful siblings can all make deposits into an ABLE account. So for that reason, we do see balances in the ABLE accounts grow, but you'll want to be aware of a $100,000 ceiling on ABLE accounts if SSI is involved. So if a young person is receiving supplemental security income, otherwise known as SSI, then they would want to make sure that they're keeping their ABLE account balance under the 100,000, because at 100,000, Social Security is going to cut off the SSI. Without SSI, SSDI perhaps instead, the limit as to how high the ABLE account can go in Indiana is $450,000. If the SSI recipient's ABLE account goes over 100,000, Social Security simply suspends their SSI benefit until it drops back down under 100,000. So that's, yeah, kind of gives you some of the particulars about ABLE accounts. Let's talk about how ABLE accounts were enhanced. So these are some of the improvements that were made as a part of the 2017 Jobs Act. And the tax and penalty-free rollover up to $16,000 from a 529 account became possible in 2017. That means if you saved for college and then were unable to use the funds saved for college, then you could transfer the 529 college account over to an ABLE account. And then an ABLE account has a much broader array of eligible expenses that it can be used for. So really very cool. Credit for qualified retired savings contribution may be eligible if filing taxes due to earned income. And then account holders with earned income enjoy a higher contribution limit. So this is where one is not enrolled in a retirement plan at work. Then they, in addition to the $16,000 from their wages, or $16,000 that's put in, from wages or monies that they've earned or this type of thing, you actually can go beyond that up to an extra $12,880. So the ceiling is fairly high in terms of what you can put into an ABLE account. Please keep in mind that there is a Medicaid payback with ABLE, and that means the state does reserve the right to step in upon the death of the account holder, the young person with special needs, and seek to reimburse themselves for benefits, including Medicaid waiver services, et cetera. So they can seek to reimburse themselves from ABLE benefits. Part of that's because the disabled person's own money is welcome in an ABLE account, and usually wherever a disabled person's money can go, the account can have a Medicaid lien or a Medicaid payback involved with it. But you can see a broad array of expenses here: education, housing, transportation, on and on it goes. Much more flexible, much broader than the expenses a 529 college account can be used for. So we sometimes assist families in moving monies out of a 529 over to the ABLE account and enable the ABLE account then to be accessed for just a myriad of expenses. And ABLE functions tax-wise very similarly to the 529. The withdrawals are, well, money's going in or after tax, it grows tax-free, and then withdrawals are tax-free. So you do get a tax break in using an ABLE account. And that's the payback, where Social Security will figure out just what it costs them. Or Medicaid will figure out what it costs them to provide benefits during the lifetime of the individual. Actually, for ABLEs, it goes back to the inception of the account. So if the account were set up at their age 20, it would be Medicaid benefits paid post age 20 that the state may seek to reimburse themselves for. Indiana, of course, decided to opt for it, so it's great. In Indiana, it's called Invest Able. You see that at the bottom bullet point, Invest Able. And it's a program that you can actually set up on your own by going on the Indiana ABLE website. So you go on, you answer maybe a half a dozen questions, you enter an account, a bank account number and a checking number, this type of thing. And then you can transfer monies from the bank account you've entered on your ABLE paperwork, over to the ABLE account. The new news for Invest ABLE, or the Indiana ABLE plan, is that in 2024, they're going to start providing a state income tax credit for those making gifts to an ABLE account. So it's not quite the $1,500 that the college accounts are. And by the way, the college accounts were at $1,000, and next year they're going to $1,500. So they're working to keep up and keep supporting our, supporting our loved ones with special needs, et cetera. So very excited about the state tax credit. Now, it's my understanding it will function like the 529. And the way the 529 state tax credit works is you make a deposit into an ABLE account during a calendar year, and then 20% of that deposit represents a state income tax credit. So if you were to deposit $1,000 into an ABLE account, as an example, then that $1,000 could be listed as a tax credit when taken times 0.2. So 20% of what gets put in has been a state tax credit for many years. So they're looking at tax advantaged ways to help people utilize ABLE accounts. And we've had great success with the many tens of thousands of ABLE accounts that have been established here in Indiana. This just walks through a little bit about the process of setting it up. It's a self-help situation, and though there is a phone number to call, but usually from the time a person starts, a half hour later, they have the account established. All right. So this is talking about some situations that may not work as well for ABLE. So kind of when it works and when it doesn't. So an example of where an ABLE account may not save the day would be an inheritance. These amounts are frequently more than the limit that could be deposited into, into an ABLE account. So, so you've got that limitation of $16,000, and if there's $50,000 they've inherited or something, that's not going to work, of course. Contributions are not coming from the individual with a disability, and therefore could go to a third-party special needs trust. And we just talked about that, contributions are not coming from an individual. So in that situation, maybe best not to put it in an ABLE. So if it's coming from a grandparent or parent or that type of thing, maybe better for it to go into a special needs trust that does not have a Medicaid payback on it, so that the state would not step in and take funds from the account upon the death of the family member. Beneficiary with disability whose origins came after the 26th birthday. So if there's no way to prove that the disability exists prior to 26, at this point, not a good fit. The beneficiary cannot make financial decisions, and ABLE accounts can be used in combination with other vehicles, including special needs trusts, which are amazing. Special needs trusts are just incredible. I enjoy helping the special needs community understand how ABLE accounts are a tremendous help for your loved one. These are examples of where an ABLE account may save the day. So we have three. The first is a grandparent dies and leaves $10,000 directly to each grandchild. For the grandchild with special needs, it must be spent, used to prepay final expenses, or it could be deposited into an ABLE account. The benefit of depositing it into an ABLE account is that the funds are in there to grow and build tax-free, and again, build up to where they can really purchase or make something significant happen. Example number 2, school bus incident at school results in a lawsuit. Oh, by the way, I should mention that all of these happen. Every time I tell a story or kind of give a setup, I didn't come up with this. These are real life situations that I've worked with, working with somewhere close to 3,000 families. I just have an endless number of stories that I can tell. So in example number 2, a young girl was in a wheelchair and she was being transported to school, and her chair was not properly restrained. And so the door to the special needs bus was opened, and the young girl rolled right out the door and face planted on the asphalt. By the grace of God, there were no facial fractures. It was just cuts and scrapes and lacerations, this type of thing. The family nevertheless did sue, understandably, and eventually came to a settlement of $15,000 for her injuries. The problem is that the daughter was on a Medicaid waiver. So she was on a Medicaid waiver, and while Medicaid will overlook assets that the parent has, they will not overlook assets that are belonging to the individual with special needs or the consumer. So that $15,000 would have caused that young girl who was non-ambulatory to lose her Medicaid or Medicaid waiver services, et cetera. It would have been awful. So as a result of sweeping the $15,000 into an ABLE account, her benefits were retained and the funds were set aside for future use. Example number 3, an individual with special needs gets a job resulting in earned income. They want to save some of it for a vacation, furniture, additional schooling, vehicle, etc., while maintaining SSI, Medicaid, Medicaid waiver, etc. An ABLE account would allow them to allow their funds to accumulate for future use without being subject to the $2,000 resource limit. So this is really key. The ABLE account, if properly established, does not count toward the $2,000 resource limit for both SSI as well as Medicaid eligibility. So that's pretty exciting, is being able to utilize an ABLE account so that one's savings, one's funds or accumulation can exceed $2,000 while not forfeiting any of their government benefits. So here's a couple of other situations that are interesting, because it's important to understand that ABLE accounts do address resource issues. So if one is concerned about their savings getting north of $2,000, which would render them potentially ineligible for SSI, Medicaid, Medicaid waiver services, and so forth, then they could set up an ABLE account, and funds that would otherwise put them over $2,000 could be swept over to the ABLE account to keep them compliant. But let's look at a couple of examples here. Do keep in mind, though, that ABLE accounts do not fix income issues. They are great resources to keep one's available resources under $2,000. But it really fixes resource issues as opposed to income issues. And let's talk about it. So a consumer age 22 is receiving SSI and has a part-time job earning $500 a month. Placing his or her $500 paycheck in an ABLE account will not allow him or her to avoid the reduction in SSI, meaning earned income and the reduction. So how do they reduce his SSI benefit? They start with the $500, and that's $500, of course, in paycheck, as you see above. And so they waive the first $85 of income, leaving $415. Then it's a $1 reduction for each $2 earned. So the reduction in SSI would be $207.50. So the ABLE account will, however, help keep his bank and savings representative payee account under $2,000 for continued benefit eligibility. So you can see that a person is almost always financially ahead for working, even if they have SSI and Medicaid, because if that person was earning $500 in a month and Social Security benefits were reduced by $207, but they were still north maybe of $600, then that's $1,100 of income for that month. So, we just try to maintain eligibility for the important benefits that help add to your quality of life. Example number 2, consumer age 35 is receiving $500 per month SSDI from their own record of employment. So they went to Social Security and said, I'm earning money, and Social Security found that they were insured for disability. And so they set up a claim, and sure enough, the person starts receiving Social Security disability benefits. The problem in this case is that there's actually too much income coming in. So there are some situations where there's so much income that we set up at the very bottom a Miller Trust that enables them to continue being eligible for disability, Medicaid waiver services, et cetera. So it's great to maintain this eligibility and get the most out of these benefits. So I'm pleased to say that we're actually finishing just a little bit early, but that's because we've not had a plethora of questions. These are my office addresses. You see the Louisville address, which is where I'm actually headed tomorrow morning for meetings, in the Indianapolis address. I also, of course, consult with families by Zoom. There is never a charge for an initial consultation, and we typically set aside about an hour 15 to an hour 30 minutes for each family. And then we're able to drill deep into your situation and where you're at in your journey and what are some appropriate next steps. So as a result of participating in this evening's workshop, I'm pleased to make available to you a free consultation so that we can look at where you're at in your journey, and again, what you may want to consider for some follow-up or appropriate next steps. Let's see here. I don't see any questions in chat. Does anyone have questions about the ABLE accounts or guardianship? Okay, here we go. Alrighty, if you do, put it in chat or unmute yourself if you're able to, or whatever. Let's just let us hear from you in some way so that we can address any questions on both ABLE or on guardianship. So I think these two workshops paired together are not quite as overwhelming as like the one on government benefits and that type of thing. So this is an easier presentation for me and perhaps for you. Maybe that's why we don't have as many questions. But I do encourage you to take advantage of the free consultation, absolutely free, it costs you nothing, and love to see how the information and material that we're covering in these workshops can help toward a better quality of life for your loved one with special needs and certainly provide you with peace of mind. So with that, I yield the floor back, and I'm so thankful for having the opportunity to visit with these wonderful families this evening.
Thank you, Gordon, for coming. I learned new things, especially about moving from state to state. I had never heard that before, so that was very interesting. So,
all right. Well, I think you, thanks for having me, and I think we can look forward to coming back. I think you said perhaps in a few months or something. And there are more topics, more information.
Yep, we're
that I'll-
looking.
more topics to cover, more information to bring, and I'll be so excited to do it for you. So we appreciate all the good work of my autism ally. Being a parent myself, the sense of community is so encouraging. So thank you. Thank you for what you're doing for the families, and I'll look forward to staying in touch with everyone. As you get a follow-up email from Jamie Sturchy, our parent advocate, please respond indicating you'd like to take advantage of the free consultation, and we'll get that scheduled for you. Zoom is fine. You don't have to leave your home. We can make it super convenient for you, and I hope to be visiting with many of you by Zoom in the coming weeks. Again, thanks so much for allowing me to visit with you this evening.
Thank you, Gordon. We appreciate it. Bye.
All right. Bye-bye.
My Autism Allies Autism Acceptance Walk returns to the Allen County Fairgrounds Sunday, September 11th from noon to 4. It's an afternoon of activities and resources for the whole family, including supports for those on the autism spectrum. Food trucks, a vendor fair, pony rides, face painting, sensory play, balloon artists, and much more. And it's all free to attend. The Autism Acceptance Walk at the Allen County Fairgrounds, September 11th from noon to 4. Visit myautismally.org for more info. Presented by Hot 1079.